This is Constitutional Rights in Black and White. It was around noon on a Saturday when a caravan of 4 police cars converged on a West Chicago neighborhood. Sam Wardlow was a middle-aged man from Chicago. When he saw the police, he ran. The police chased him down and cornered him in an alley. They searched him, and they found a gun in a bag that he was carrying. Mr. Wardlow was prosecuted for that gun, and he was sentenced to 2 years incarceration. His case went to the Supreme Court, where he argued that when he ran, the police had no evidence that he had committed a crime or done anything wrong, and therefore they should not have been permitted to stop and search him. Yes, they did have evidence, said the Supreme Court. You engaged in headlong flight when you saw the police, and you did it in a high crime area. Taken together, this is enough suspicious evidence for police to stop you. But wait, said Mr. Wardlow. Okay, not Mr. Wardlow, but his lawyers on behalf of Mr. Wardlow. I had the right to run. This court has said that every individual has a right to ignore the police and go about their business. I was exercising my right to avoid the police. If that exercise creates an excuse for police to stop me, it's like I didn't really have the right at all. Oh, you still had the right, said the Supreme Court, but you did not simply avoid the police. You engaged in unprovoked flight, which, by its very nature, is not going about one's business. In fact, it is just the opposite. Police can consider that when they're deciding whether to stop you. I don't know, said Mr. Wardlow. Lots of innocent people are scared of the police. They have good, innocent reasons for running. Undoubtedly true, said the Supreme Court. But our cases accept the risk that officers may stop innocent people. Wow, said Mr. Wardlow. Doesn't this create a big problem for people who live in so-called high-crime neighborhoods? If they want to avoid the police, or avoid a potentially dangerous situation in the neighborhood that involves police, they can't run, because that, all by itself, will make them look suspicious. Basically, yeah, said the Supreme Court. Illinois versus Wardlow is an infamous case in criminal procedure. It opened up the door to police chases and other intrusive law enforcement practices in the very neighborhoods struggling with decades of police community distrust. Wardlow means, ironically, that the people who are most afraid of police violence and who are therefore more likely to run are therefore more likely to get stopped. Okay, let's read the case. Illinois versus Wardlow is the progeny of the famous case Terry versus Ohio, in which the Supreme Court held that police may conduct a brief investigatory stop when the officer has a reasonable, articulable suspicion that criminal activity is afoot. In particular, the court held that the suspicion must be objective. That is, the police must be able to articulate specific facts that suggest criminal activity, and it has to be more than an inchoate and unparticularized suspicion or hunch. The fight in Wardlow was about whether these particular facts met this legal standard. The 2 key facts in the case are, first, that Sam Wardlow ran when he saw the Chicago police. The second fact is that he did so in an area known for heavy narcotics trafficking, which the court refers to as a high crime area. The court explains that neighborhood is not enough. An individual's presence in an area of expected criminal activity standing alone is not enough to support a reasonable, particularized suspicion that the person is committing a crime. But neighborhood matters. The court also says that officers are not required to ignore the relevant characteristics of a location. This means that people who live or work in areas that police consider to be high crime are at higher risk of being stopped. You might take a moment to ask yourself what other kinds of areas could qualify as high crime. A shopping mall, where shoplifting is common? What about Wall Street, where economic crimes are common? How about the internet? Along with neighborhood, flight can also be considered as evidence. The court decides that Wardlow's unprovoked flight upon noticing the police was suspicious. A central problem with this holding is that individuals have a Fourth Amendment right to decline encounters with the police and to walk away. Indeed, the Supreme Court acknowledges that everyone has a right to ignore the police and go about their business. And at the same time, that refusal to cooperate without more does not furnish the minimum level of objective justification needed for a detention or seizure. Notice how this has to be true. If exercising our constitutional right to walk away from the police was itself enough justification for the police to seize us, then we wouldn't really have the right to walk away at all. The Supreme Court, however, distinguishes Wardlow's flight from the bare exercise of that constitutional right, writing that unprovoked flight is simply not a mere refusal to cooperate. The implications of this reasoning are significant. It matters how you exercise your right to decline an encounter with the police, and the manner of your exercise can be used against you. The court also acknowledges that there are many innocent reasons why people might run from the police, but it holds that these reasons do not defeat the police power. Rather, Terry versus Ohio and its progeny accept the risk that officers may stop innocent people. This acceptance is a pervasive characteristic of Fourth Amendment law generally. Reasonable suspicion and probable cause in the context of arrest both require far less evidence than certainty. Indeed, the court has held that probable cause is less than a preponderance of the evidence. Put differently, it's perfectly legal for the police to arrest someone, even when it is more likely than not that they are innocent. Reasonable suspicion is even less evidence than probable cause, which means that even more innocent people can constitutionally be seized under the standard. Taken together, these two facts, unprovoked flight and the designation of a neighborhood as high crime, are enough to satisfy the reasonable suspicion standard, which meant that police had enough evidence to stop Sam Wardlow. Wardlow was a 5-4 decision, very close, and the dissent is substantially longer than the majority decision itself. I have given you just a few key excerpts here. Justice Stevens disagrees with the majority that these kinds of facts should be enough to permit police to stop an individual. Or, as he puts it, the question in this case concerns the degree of suspicion that attaches to a person's flight, or more precisely, what common sense conclusions can be drawn respecting the motives behind that flight. Justice Stevens points out that people have many innocent reasons to run, and that therefore it's unreasonable to infer criminality when they do. In particular, he notes that in high crime areas, people are especially likely to believe that contact with the police can itself be dangerous. In other words, people like Sam Wardlow in neighborhoods like the west side of Chicago might have especially good reasons to run from police that have nothing to do with their own guilt. Justice Stevens concludes that there are too many innocent reasons for people to run in neighborhoods like these for this kind of evidence to meet the standard. Illinois v. Wardlow was decided in the year 2000. 16 years later, the Massachusetts Supreme Judicial Court adopted the dissent's reasoning. Jimmy Warren ran from Boston police, just like Sam Wardlow did. Boston police stopped Warren at gunpoint and then prosecuted him for a gun that they found nearby. The Massachusetts Supreme Court held that Warren's flight was not sufficiently suspicious to justify the stop. The court noted empirical evidence that Boston police tended to racially profile Black men, and that this provided strong, countervailing reasons why a person like Jimmy Warren might run. The court wrote, "Where the suspect is a Black male stopped by the police on the streets of Boston, The analysis of flight as a factor in the reasonable suspicion calculus cannot be divorced from the findings in a recent Boston Police Department report documenting a pattern of racial profiling of Black males in the city of Boston. The Massachusetts Supreme Court continued, such an individual, when approached by the police, might just as easily be motivated by the desire to avoid the recurring indignity of being racially profiled as by the desire to hide criminal activity. Given this reality for Black males in the city of Boston, a judge should, in appropriate cases, consider the report's findings in weighing flight as a factor in the reasonable suspicion calculus. Commonwealth v. Warren is a good reminder that state Supreme Courts don't always have to agree with the United States Supreme Court. Those courts have their own authority to interpret facts and case law, and even their own state constitutions in ways that are more protective of individual liberty. On April 12, 2015, a young man ran from the Baltimore police. His name was Freddie Gray. The police chased him down and stopped him on the authority provided by Illinois versus Wardlow. Specifically, the police report stated as the reason for the stop that Gray fled unprovoked upon noticing police presence. I've given you a copy of the Baltimore police report so you can see for yourself how closely the language of that report tracks the language of Wardlow. In what is now an infamous story, Freddie Gray had a knife in his pocket. It was legal, but the police arrested him anyway. They arrested him with so much violence that a bystander filmed Gray screaming in pain. Police put him into a van and rode him through the streets of Baltimore so roughly that his spinal cord was nearly severed. Freddie Gray spent 7 days in a coma, and then he died. Thousands of people flooded the streets of Baltimore to protest his death. State's Attorney Marilyn Mosby prosecuted those police officers. And now you can see how it was Illinois versus Wardlow that made this scenario constitutionally possible in the first place.